At this time, I'd like to call the meeting to order. Today is Thursday, May 22nd, 2025, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. We would like to begin by acknowledging that the land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Tongva and Gabrielino Quiche peoples. At this point, could you please rise and recite the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And for those who might be following on video, my name is Frank Roy. I'm the Vice Chair for the Rent Stabilization Commission. I'm going to start the meeting this evening, and we are expected to have our chair join us shortly, and at that point he'll take over, but I'll get us started so we can get through our matters. At this point, Ms. Secretary, could we do a roll call?
Sure. Commissioner Copeland?
Here.
Commissioner Goldman?
Here.
Commissioner Krupes? Commissioner Topshin?
Here.
Vice Chair Rory?
Here.
Chair Bass?
Presently absent, but soon expected to attend. We do have 4, that is a quorum, so we can move forward with our meeting. The next item is the approval of the agenda for tonight's meeting. If everyone has had a chance to review, I'll entertain a motion.
Motion to approve.
Second.
We have a motion and a second, and so can we do another roll call, please?
Commissioner Copeland?
Aye.
Commissioner Goldman?
Aye.
Commissioner Topshin?
Aye.
Vice Chair Rory?
Aye. All right, so that motion passes, and we'll move to the next item, which is the approval of the minutes from our last meeting, which was May 8th, 2025. I'll entertain a similar motion in a second.
I'll move to approve the minutes, Chair.
Okay, we have a motion.
I'll second.
All right, second.
Can we pause for one moment?
Yeah, let's pause.
you.
I think our chair is entering the room, so as promised, I'll be handing off the baton at this point.
Thank you. My apologies for being late. So my understanding from the Vice Chair is that we have a motion and a second on the minutes, and it is time. I've reviewed them in advance of the meeting, and with that, it's time to call roll.
Commissioner Copeland?
Aye.
Commissioner Goldman?
Aye.
Commissioner Topshin?
I'll abstain since I was not at the meeting.
Vice Chair Rory?
Similarly abstain since I wasn't at the meeting.
And Chair Bass?
Aye. That motion carries with 4 votes. Or 3 to 2. Sorry, I have to do the math the other way around. We will now move on to the next item on our agenda, which is public comment. Do we have anybody who wishes to address us this evening?
No.
Okay. There will be another opportunity at the end of the meeting if somebody chooses to address us on anything that's not on the agenda but within our purview. So now we'll move on to item number 7, our manager's report. Mr. Kessinger?
Yes, thank you, Chair. Good evening, Commissioners. It's nice to see you. Congratulations, Vice Chair, on your reappointment. The first thing you'll notice maybe looking at the look-ahead calendar is that it's much shorter than prior look-ahead calendars. I think that's a very good thing. So I wanted to recognize that. One of the goals that I had was to sort of catch up on some of this backlog of cases that we had before the summer, so we could focus on some of the other duties that we have this summer, and I think this shows very good progress. So thank you all the commissioners who kept a good attitude and were willing to sort of stay here later so that we could have 3 appeals per night and sort of work through this backlog. I really appreciate that. Tonight we'll have 3 appeals. We have 3 appeals next week. There's currently only 1 appeal scheduled for June 26th, along with some important announcements related to the annual general adjustment, relocation fees, and temporary relocation expense schedule. You'll note at the bottom of the look-ahead calendar there are some other events of note taking place this summer. In July, we're going to have the reorganization of the chair and the vice chair. And likely in the first meeting of August, we'll have a discussion related to the increased evaluation guidelines and the interest rate on security deposits. That's also when I plan to bring back conversations proposed by Commissioner Copeland and Commissioner Kerpes related to the formation of an ad hoc committee for the evaluation guideline discussion and a discussion on the future of the security deposit interest calculation. So we'll certainly have a busy summer, and again, appreciate all of your work to get us to the place we are now so that we can have those discussions. That concludes the manager's report at this time, but I'm open for any questions.
Thank you very much. Do any of my colleagues have questions? Commissioner Topchin.
Thank you. Just quickly, Mr. Manager, what are the dates for the meetings in July?
It would be generally the 2nd and 4th Thursday. I'll defer to the secretary in case she has those dates available.
Okay.
Yeah.
Thank you.
It'd be July 10th and 24th.
And for quarter 3 and quarter 4, do you have any sense of the amount of appeals that we might need to work through? Would it be consistent at 3 appeals per meeting, or might that taper in Q3 and Q4 based on just estimated guessing this evening?
If I had to wager a guess, I would say we might be moving towards 2 appeals. It's hard to sometimes anticipate how many will come in, but for the majority at the beginning of the year, we've been facing sort of a backlog from the prior calendar year. We're ahead on that, so I think it's much more likely we'll be able to move to 2 appeals.
And one question from me, and that is we have a fully appointed 7-member commission again, which is exciting. Do we know when our 7th member will be sworn back in, Commissioner McCafferty?
I'm not sure if we've reached out to Commissioner McCafferty to confirm, but we're hoping the next meeting. Yes, it looks like we have confirmed. So,
Fantastic. It'll be exciting to welcome her back.
yes.
Anyone else? Okay. We will now move on we have no new business, and so we'll move on to our appeal section of the agenda. And the process that I outline here is what's going to happen for all of the appeals, but essentially we will ask our city attorney to provide a staff report, and then we will turn to the person who appealed, whether that be the tenant or the landlord, to address us first. They will have the opportunity to divide their time. They have 5 minutes. They can divide it however they want, 4 minutes 1, 2.5, however you want to divide that. Just tell us up front. Then we will turn to the respondent, the other party. They will not have the opportunity to divide their time, and then there will be an opportunity for rebuttal. So that's generally the process. I'll remind you of that when we get to each of the appeals, but so you can plan ahead. And let's turn to our first appeal this evening, which is D4987 at 1125 North Vista Street. Mr. City Attorney, can we have a report?
Yes, good evening, everyone. My name is Kellen Martz, Legal Counsel to the Rent Stabilization Commission. As the chair noted, this is appeal number D-4987, 1125 North Vista Street. In this matter, the tenant filed a rent decrease application for the property located at 1125 North Vista Street. The tenant has lived there since 2015. The rent reduction application was for 2 issues. It was for a garage and storage area issue and then a patio space issue. The owner has filed the appeal in this matter, and they have stated that this is a clearly in error reasoning. A hearing was conducted before a hearing examiner in January of this year. Both parties appeared and offered testimony and evidence. As to the garage storage space area, this is a atypical garage space that's kind of sealed off and used for storage and not for vehicles. The owner said that they issued a notice to the tenants to remove their items from that garage when they purchased the property. The tenant had stated that they used that area for storage of their belongings, and that when they did receive that notice, they removed those items. the owner has stated that that area should be used only as a garage and not for storage of belongings, and it is a fire hazard and potential insurance issue. As to this patio space, this is a patio space outside where there's chairs and other items, and that current use is for vehicle parking in that area. The owner has stated that that area is blocking access to the garage and needs to be vacated. And a decision was issued in this matter in February of this year as to both issues, the garage storage space, the patio space. The decision found that both of these were reductions in housing services and issued a rent reduction for the garage storage space of $253 as a common area issue and loss of patio space for $75. And again, the landlord has filed the appeal here, claiming that the decision is clearly in error. Owner argues, again, that there is a hazard issue with using the garage storage space, and that there are potential business activities being conducted from the property. However, no evidence of that was provided. And then as to the patio space, that was not appealed, so that decision as to the patio space is final. And so the question before you tonight is whether there is substantial evidence in the record to support the hearing examiner's determination regarding the pre-existing access to the garage storage space area. Staff recommends upholding the hearing examiner's decision, finding no error and that there is substantial evidence in the record. Most of the appeal does not hinge on an argument that there was no use of that area by the residents prior to the owner taking over the property in 2024. Rather, that such items are potentially dangerous, the business, running a business issue, and potential insurance issues. Staff calls your attention to Rent Stabilization Regulation 60041C, which says that a reduction of rent is applicable to all substantially reduced or discontinued housing services, regardless of whether the housing service was created or established in violation of any provision of law or insurance provider requirement. The value of the housing service shall not be adjusted downward if the discontinuance or substantial reduction is attributable to bringing the property into compliance with any legal, regulatory, or insurance provider requirement. So what staff believes that means is that even if the insurance company for the property says you need to remove this, it's a hazard, the rent reduction would still be valid. And so that's an issue between them and their insurance carrier, not for the analysis of this issue. So with that, staff recommends that the commission affirm the hearing examiner's decision in full and adopt resolution RSC 25682 saying the same. And that concludes my report.
Thank you very much. Are there any questions for staff at this time? Not at this time. Thank you very much. So we will turn now to the appellant. In this case, it is Brian Tannenbaum, the landlord. And again, just to remind you, when you approach, you introduce yourself by name, city of residence, and then please let us know how you'd like to divide your time so the secretary can keep track of that.
Mr. Sanagan, the managing agent of the building, is here tonight to speak, and I'm willing to speak. You want to give him you have that little thing? And if this time remains, I will speak. You want these things?
You could give that to the secretary. That would be great. So again, your name, city of residence, and how you would like to divide your time.
Okay. I'll say a few words. Brian Tannenbaum, my city of residence is Los Angeles, Tarzana, Los Angeles.
Okay.
The property is West Hollywood.
Right. And then how would you like our secretary to keep your time? Do you want to just use your 5 minutes? Or do you
About a
want...
minute, 1 minute.
Okay, so 4 minutes and then...
I want him to have the time that he wants.
Great, thank you.
Okay.
You can proceed.
Okay, in my opinion, the tenant has not been able to show any proof that they were entitled to the use of the garage. The building has one garage, and they had they cannot show proof that they had use of the garage. So I wanted to say that. What was the other account, sir, Mr. Attorney? What was the other account besides the garage issue?
You need to address the commission at this point in time.
sorry, okay,
You can
Mr.
address the
Bass?
commission, but it's not a back and forth, sir. So
I'm sorry, sir?
you can address the commission, but it's not a back and forth.
Oh, the storage area. We have a picture of the storage area. It's still there. It's open, and it's nothing inside, but we have a picture of it, which Mr. Sadagon will show you. and he will take over. So if those are the two issues, I said my piece. I'm going to let Mr. Satagon take over.
Thank you very much.
So basically, the storage has not
And
been.
could you please just introduce yourself, name,
Sean
city?
Stadgen, I'm the owner of the property,
Okay, and city of residence?
LA, California.
Okay, and would you like to reserve any of your time for rebuttal?
No.
Okay.
So we have not touched the storage, the outside, and this is a picture from this morning, by the way, that I went there myself and I took. I have the pictures here, if you guys want to see it, you know. As far as the garage, they had empty boxes when I took over the building, and it was junk, and I papered both of the tenants in the front. I said, if this is junk, please remove your belongings. The other tenant, she said, please throw it away. I threw it away. They didn't say anything. I have nothing in writing that they contested it, and there's no evidence at all. I also want to include that the storage is a big storage, and it's right in the driveway. It's sitting outside, and nobody can park any cars, and this is a parking space for people to park their cars. So, and as far as the other issue, as far as the sitting area or anything like that, nobody touched anything. As far as any patio furniture, we have not touched anything. We have not removed anything.
Okay.
So, if that's what we're talking about.
Okay.
Let's see what else I have. And as far as, there was also some complaints about cutting trees and all that stuff. I have evidence that it's been taken care of. There was been some reductions of rent of not having a gardener. I have a full staff that works for me. We're there once a week, and everything is taken care of. And there's some other issues that we had in the past, and the tenant has refused to give us entry, and I have evidence with the city of West Hollywood, with the code enforcement, because they went to the office on a daily basis, you know, and complains and complains and complains, and city of West Hollywood told me that I should get in there one more last time, and we never got access. You know, I have all these emails, I have everything in writing. Everything has been fixed. The fan and every issue has been fixed. And I know that there's an application that Mr. Tannenbaum found that we have not done. There's an application that I guess we need to fill out for someone to come and inspect it afterwards. We have not done so. But everything is fixed. Whatever is missing, installation, whatever, all the complaints there, it's all fixed.
Chair, I'm sorry to interrupt. I think it's important to put on the record that we have two appeals here tonight. It sounds like you're speaking to the second appeal. And so issues with like the gardening and whatnot is for the second appeal. So what's before you tonight is the garage space and the patio space. The next case deals with other issues.
Copy.
I appreciate that. Thank you.
Copy. So as far as the garage belongs to the unit in the back, first of all, and that's the parking spot. And we can't just have a box, and I don't know what's in the box. It might be a fire hazard. It was literally junk, and I basically papered both of the tenants. They never, you know, said anything. So I never took away their rights, and I asked them to show me anything in the lease. There was nothing in the lease that states that they have rights to the garage. That's as far as the garage. As far as the patio, furniture, spaces, or anything, that we have not removed anything. And as far as the storage is still there. That's pretty much it.
Thank you very much. Madam Secretary, how much time does he have left?
40 seconds.
Okay. So at the conclusion of the tenant's remarks, you'll have 40 seconds to provide a rebuttal if you choose. But before you sit down, I want to ask my colleagues if they have any questions of you at this time. Commissioner Topchin?
Yes, good evening, sir. You mentioned that there is no evidence. Evidence of what, and what did you mean by that?
I meant if there's a lease, I'm sure that the garage should be in their lease, or any kind of evidence when I paper them. If this is important, and you guys is this a junk? You guys want to take it away? So
Okay. So you're referring to the garage and storage. Garage and
The garage,
storage. that
we're
there is
talking
no
about, we're
evidence.
talking about the garage here, right?
Yeah, I'm
Yes,
talking
the
about
garage.
So you mentioned the evidence, so that's
Yes.
about the garage and storage. And can I ask you when you became the owner of this property?
I don't recall, it's almost about a year, 2024, but I can't tell you the exact date on top
Okay,
of my
it's
head.
about a year or so.
Almost, yeah.
Okay. But when you became the owner, when you purchased the property, so you realized that the tenants were using the garage / storage.
It wasn't really being used. There was a couple of boxes there that, to me, they were junk. But I sent him notices on the door saying, you know, if this is junk, do you guys want to take it away, or I'll throw it away for you guys? And I was, you know, the lady,
Right.
one of the ladies said, okay, yeah, please help me throw away my junk.
Okay, thank you, sir.
Thank
Nothing
you.
further this time.
Commissioner Copeland, I think you had a question, or?
Thank you, Chair. Yeah, I just wanted to clarify something you mentioned, that it was not at the direction of the owner to remove things from the patio area, plants and whatnot. But there was some email exchanges that did mention cleaning up the storage as well as the patio space area in back of the unit. So
I came in one day and you know, when I got the insurance, the agent told me just make sure if there's anything in the storage, you should open it and inspect it. And when I opened it, I saw some paint.
but as far as, I'm talking about the patio, as far as the plants and everything on the patio area itself.
The patio area, I mean, if there's plants, we didn't tell him to remove it. And we're talking about the shed. You know, I don't think anything was there. I mean, if there's any pictures that you guys want to share, that's no problem. I don't recall any plants on the patio. Maybe it was around it. I don't recall. It's been a while, but we're talking about the shed.
Okay, thank you.
Thank you.
Thank you, Chair. That's it for right now.
Thank you. Vice Chair.
So we're talking about the garage. I think the shed is for the next appeal. For the garage itself, there was an allegation in some of the materials that after the tenants' items were removed, some of the landlord's items were stored in the storage area of the garage. Is that correct?
Not necessarily. I mean, they're my item, but they're not stored. They're not stored. I had some files that I take in and out, but they're not stored there. You know, I don't use it as storage. I have many places that I can store my items.
So if I'm understanding you correctly, you did keep some personal files in the garage
Some personal files, yes.
after the tenants' items were removed.
And in the meanwhile, until I get to, you know, to rent the unit in the back, because we just evicted the lady in the back, and that garage belongs to the unit in the back.
Okay. The other question I had was, there was a picture in the record about a truck that they said was parked in the back, and I'm curious if that was in front of this garage area that we're talking about, or do you park a truck vehicle in front of this
I don't
garage
park,
area?
that's my truck. When I pick up stuff, I park it there overnight, and you know, if I want to pick up something.
From the
I don't-
garage?
yeah.
Like your personal files or something
Yeah,
you want to pick up?
Yeah, I don't park my truck there.
Okay, that's all.
I don't
Thank
park
you.
my truck there. That's what you know.
Commissioner Goldman, do you have questions? Okay. I just have one for you really
Yes, sir.
quickly. And that is just trying to get right down to the point of this when we're talking about the garage.
Yes, sir.
When you took over ownership, do I understand it correctly that there were items belonging to the tenants in there, junk or not junk, there was stuff in there, and you gave them notice to remove it?
I gave them a notice to see if they want to, if it's junk, if they don't want to keep it, if they want to remove it. You were contesting, is the garage
So they
belong?
had stuff in there and you asked them to remove it?
I asked them if the
Or
garage,
you could throw it away?
yeah.
Right, okay, thank you. Anything else? You'll have 40 seconds for rebuttal. We'll turn to the tenant now, so you're welcome to take your seat, and I'll call you back up if you choose to take that time.
Thank you.
Thank you. We'll now turn to the tenants here. Fabian Rigaud, please correct me on any mispronunciations. I want to get it right. And Brent Winter.
My name is Fabienne Rigaud.
Thank you. And if you could just state your name, city of residence, and you will have 5 minutes. And just about the garage, like we gave the advice to the landlord.
Right, you want me to tell you where I live? Okay.
Just for the record, yes, thank you.
1125 North Vista Street. Now, first I'd like to thank the examiner, the hearing examiner and the commission for the decision that you took, on our behalf, Brent and I. And now, as far as the garage, yes, we had it's not it's a storage garage. A car cannot be parked there because pretty much it's being blocked. It's not even a garage anymore. It's a storage. And we used that since 2019. After the first original owner left, sold the property, he gave us authorization to use the garage as a storage. And since then, we've been using it until this new owner asked us to move all our things out of it. Later in August, since we started getting notice. And yes, there was a lot of things which belonged to us that we cared for, that we had to get rid of or store elsewhere. And that's basically what it is, But now, as far as the storage, as far as the garage, the landlord is now storing his own belonging. He had a lot of things, I don't know, stuff that he's selling, maybe stuff that he's like using to furnish another apartment, but there is a lot of his belonging now. And eventually he told us that he wanted us to move the things from the garage because he wasn't sure what he was going to do with it. Maybe do a AUD or a garage again, reconverting it as a garage, but he's never done it. Basically, he's using it himself as a garage. And that's for the garage part. Now, as far as the patio, since 2015, when we moved in, we had our, I put some plant, some umbrella. There was a, very, very nice little area behind our unit, which I really cared for. And it was not, I had it since we moved in, taking care of my plants and things. And when the landlord took possession of the property, he asked me to remove all my plants and all the arrangement I had. And actually, I like to mention, because he mentioned the lease, we do have an estoppel. We stipulate that we do have storage. So it might not be on a lease, the original lease, which actually now is a month-to-month, but it is on our estoppel that we signed prior of the new landlord acquiring the property. And actually, we signed it in such a way that the previous owner could sell the property. He asked us to fill out the estoppel in function of selling the property. And the new landlord knew about it because I sent him the estoppel when he was wondering. He had many copies of it because I did a lot of communication through email with him, mostly me, because I was responding to his notices, which was like, we were getting notices just about every day. It was becoming so overwhelming. So as far as the patio and the garage, that's the story. So if you have any question.
Are you done?
I'm done for.
We want to give you the whole 5 minutes, the same as we did the landlord. So
was it 5 minutes?
You still have more time, but you have to use it all at this time.
You have 1 minute and 10 seconds remaining.
1 minute. You want to say something?
If you're done, you're done. That's fine. I just want to make sure you have the opportunity.
I'm pretty much done, unless you want to ask me some question in which I will respond.
Okay. Well, then, with you being done, Commissioner Copeland has a question, I think.
Thank you, Chair. Yeah, when you mentioned that you had to clean your items out of the garage. Was this in response to a 15-day notice that came out to the residents from the owner to clear out the items out of the garage?
Yes, it was in response of the notice we were getting.
Okay. so
Actually, we started getting notices. Those notices were even prior of him, I mean, Sagdan, you know, Mr. Sagdan, to become the landlord. He became the landlord on, I believe we got a notification from the previous owner. He became the landlord on August 14. That's when I guess they signed the paper. That's when we got the notification.
Okay, so it was in response to the written notice to clear, for tenants to clear
Well,
items
it
out?
was, it was, because he was sending us notices even before being the owner. Like, the first notice we got was August 12.
Okay.
And yes, he was asking, it was like non-stop asking, you know, sending notice to do this or
Okay.
comply to this, you know, basically it was, okay.
Okay,
So.
thank you. Appreciate it. Thank you, Chair. That's it for me right now.
I think that's it. Thank you very much.
Thank you.
So now we will turn back to the landlord. You have 40 seconds for any sort of rebuttal. Yeah.
At the previous hearing, where we sat in the conference room, we presented our lease agreements to the hearing officer. There's nothing in the lease agreement that shows a tenant's right to that singular garage. A 3-unit building, 1 covered enclosed parking space. No tenant has in their lease a right to the garage, usage of the garage. I wanted to say that and make it clear to you. No place is it written an entitlement. Putting your possessions in a place doesn't give you the right to claim you have the right to the location, putting it there. The next issue is an issue of shed. I have pictures here of the shed.
I'm sorry, sir. Your time has expired. Thank you very much. Any additional questions? Okay, thank you very much. And I will start off by saying that the entire record that was provided to the hearing examiner in the conference room, the entire record is before us tonight. So we have all of those documents as well to review, just so everybody knows. Any questions of staff before we proceed into deliberations? Commissioner Copeland?
Thank you, Chair. Yes, I just wanted to confirm that an estoppel certificate overrides an original lease generally. Is that correct, Mr. Martz?
Not necessarily. An estoppel certificate is used to show a potential owner what they're buying, but it would be strong evidence that service, or it's not just used to show what service is. It could say, I have a pending lawsuit against the landlord, those type of things. But yes, it would be strong evidence, but it's used, and the old owner gives it to the new owner in the transaction process so that they know what they're getting into when they're buying a property.
So it would actually be perhaps proof of services that may have come after the original lease.
Absolutely.
But a
yes.
confirmation of that.
Correct.
Okay. Well, thank you, sir. That's it for me.
Chair, you had a question?
Can I just confirm that for this appeal, the patio is not an issue? We're just talking about the garage being used as a storage area?
That is correct. The patio issue was not appealed, so that decision was fine.
Okay. My other question was for the reduction that was granted as a common area item for the garage storage area. It says 253 common area issue. Is that apportioned amongst the 3 units at the property? So for this particular tenant, there would be some portion of that 253, or how does that work? And especially if one of the units has now turned and the tenant who may have been previously using it as storage is no longer renting, what happens to that number? Does that get affected?
So, excuse me, so that amount is per tenant. The decision found that it was a common area issue, and so the rent reduction applies to all of the parties. One of them leaving does not affect the others who still have that. If the prior tenant moves out, it's up to the landlord to issue a new lease to the new party, and how that garage issue is handled is between them. they would not get the rent reduction that was given to the previous tenant. Does that answer your question?
Yeah, so the 253 is per unit.
That is right.
I have a question, and oftentimes we have, I'm trying to think in general terms here, but we have situations where a landlord and tenant will enter into an agreement, and over the course of the time that they live there, short or long term, doesn't matter, over the course, a landlord and tenant might agree to change something. My unit, my building, I'll use my example. There's 8 units in the building and there are only 3 parking spots. My landlord chose to give me one of the parking spots upon vacancy of a unit that had the spot before. Because I happened to sit in this role, I made sure that that was in writing. Even though it was via email, I covered my bases. But a landlord can do that and give more, and then that, whether it's in writing or not, could potentially just become part of what the housing service is. I'm trying to say this in general enough terms that you may be able to answer it, but I think it will inform our conversation here.
Yes, you are correct. Under the definition of what a housing service is services listed on the registration forms and any other service actually provided by the landlord. And so it doesn't have to be in a lease. In your case, it sounds like it came later. And so yes, it's fact specific, but in general terms, that would become a housing service and would attach to.
And to be clear, I'm not asking you for legal advice in my situation. I have an email exchange, and
yes, of course,
I'll deal with that in the future if the landlord ever changes. But yeah, 10 years later, they chose to give me a parking spot, but it's not in my lease anywhere. But I would certainly fight for that. Putting my landlord on notice. Any other questions of staff? Then who would like to begin on deliberations?
I'd like to begin, Chair. So, in a perfect world, ideally, we would like to have the tenant-landlord relationship stipulated in a wonderful, beautiful agreement that would just cover each and every aspect of the tenancy, but that's not the case in every case. So, and as clarified by the legal counsel, in the city of West Hollywood, in order for the service to be landlord-provided housing service, it doesn't have to be in writing in the form of a lease agreement or any other written document. That's not the requirement. So, having said that, the fact that the tenant had access to this garage/storage space, which means at one point the prior owner gave that access, gave the key to the tenant and allowed to use that space for storing things. So now when the new owner takes over later on, in this case in August of 2024, the tenant by then has been already using it for years, that garage and slash storage area. So that's why the presumption is this service was given to the tenants because the tenant had access to the space. And if the tenant had access to the space and stored the items in that space, it means the landlord, the prior owner, allowed that, which became a housing service under the ordinance. That's why that the landlord's argument that there is no lease, there is no storage or garage storage space specifically identified in the lease is not really, to me, relevant at this point, or doesn't support the appeals reasoning that the examiner erred in the decision. So I think the examiner's decision is correct, and I'm just prepared to support the staff's recommendation. And again, before us, it's only the garage and storage area, so therefore I'm not going to talk about the patio. So, and another thing is, it's as the staff mentions in the report, it is really irrelevant whether the service the service may be in violation of some sort of a rule or insurance policy or something in regards to the possible hazard, because the fact remains it's a service. The tenant was given that service. So it doesn't really matter whether it's a legal service or illegal service or maybe potentially a hazardous situation created there by using that service. So it is irrelevant. So the fact remains it's a landlord-provided housing service provided to the tenant. Thank you, Chair.
Thank you very much. Who would like to go next? Commissioner Goldman?
So, I agree with Commissioner Topchain. I think staff's recommendation is on point here, and I'm prepared to affirm the decision.
Thank you. Commissioner Copeland?
Thank you, Chair. Yes, I agree with my fellow commissioners. I think that this was a service that was provided during the tenancy that was removed by the request of the new owner and warrants the reduction. And under the rent stabilization ordinance, an exception is not made for bringing something into code compliance or for insurance reasons, so that exception doesn't apply. There was also some mention of this is a common area item, so it's not really relevant when it's a common area item. Say it's a dog park or a pool. Well, only a certain number of tenants use it, or a certain percentage of the time, or not at all, or this person uses it. That doesn't really matter. It's still a common area issue, and is that the tenants were entitled to the reduction of the service. So I agree with staff's recommendation. Thank you, Chair.
Thank you. Vice Chair Roy?
I think for the landlord, the definition of a housing service in West Hollywood is very liberal, and it doesn't have to be written into the lease. And so that's probably the disagreement. But the law is the law here in West Hollywood, and this was not clearly in error. This was following the law. So I would second my fellow commissioners in adopting and affirming the staff recommendation and the hearing examiner's decision, because they're following the law here in West Hollywood. It doesn't have to be in the lease.
Thank you, and it will be a unanimous decision, I believe, but I want to add just a little bit of context here for how I'm getting to this decision, and I second everything my colleagues have said. I agree with every bit of it. I will say it's important for the landlord to recognize that these reductions are not in the city of West Hollywood considered punitive. There are oftentimes situations, and I'll use another real life example. The building directly across the street from me had this awful pool. No one ever, I've lived there 15 years. You can see right into the courtyard of the building. No one used it. And they chose to tear out the pool, and they put in this beautiful courtyard with these lights. They have parties there, tenants get together. It is used almost every night during the summer. Somebody could, who had lived there, file and say, they took out my pool, I want a reduction for the pool, and the landlord might choose to keep it the way it is because of that improvement actually makes it a better building, and they can get higher rents and those sorts of things. But a tenant would actually have an argument that they took out the pool. The hearing examiner would have to make those decisions, and so I'm not determining how that would go. But I could imagine somebody could claim they lost their pool and they want the pool back, and the landlord might choose, it's worth a reduction for these few individuals who were there when the pool was still there because I can get higher rent and it's a better property. If you choose to build an ADU in where that garage is, it might actually be a better use for you, and it might be worth having the reduction on one unit so that you can get more value from the other unit. None of those, all of those are hypotheticals, but I share them with you because these are not punitive deductions. They're meant, the tenant and the landlord at some point in time appear to have had an agreement that they could store belongings there. All of the evidence that the hearing examiner reviewed pointed to that, and therefore any reduction of that service, they would need a corresponding reduction in value or a corresponding reduction in rent. And that's the way I'm looking at this. And the hearing examiner appears to have looked at it the same way. And I don't see anything in the record that would tell me that the hearing examiner made a wrong decision. And in fact, actually the appeal to the Rent Stabilization Commission, which is signed by Mr. I believe you said Sadgan, you signed this. It actually says on the actual document that the residents here, Fabian, I'm reading from it, Fabian had been using the garage space, goes on, but basically storing items there. And that's something that you signed saying that they had been storing items there in the document you sent to us. So calling it junk tonight and these sorts of things is not what you actually put in writing to us to get this hearing. And so the evidence at the hearing plus the appeal to us tonight all point to the fact that there was storage there, and there's been nothing that convinces me otherwise. So with that, do we have a motion on the floor? I don't have any of the resolution numbers here. So Commissioner Copeland, would you like to make that?
Yes, I'd like to make a motion to adopt Resolution RSC 25-682, a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming the hearing examiner's decision as to application number D-4987.
Second.
We have a motion and a second. I will ask our secretary to call the roll.
Commissioner Copeland,
Aye.
Commissioner Goldman,
Aye.
Commissioner Topchin,
Aye.
Vice Chair Rory,
Aye.
Chair Bass.
Aye. That motion carries. If any of the parties have any further questions, you may reach the Rent Stabilization Division at 323-848-6450, by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the Services menu. Our next appeal involves the exact same parties, and we have both parties who have appealed here, so it will be a similar process as the last one, except that I'm looking for my notes here. Which appeal came first? I think that's the order we're going in. Do we? Sorry.
The landlord.
The landlord, okay. So we will do it this way. We will hear the landlord's appeal, which would allow the landlord to divide their time. There will be a rebuttal opportunity. And then when we are done with that testimony, we will then go to the tenant's appeal, where they'll have 5 minutes where they can divide their time, and the landlord will not have the opportunity to divide. We'll hear all of that, so that's about 20 minutes of conversation, and then we will proceed to our deliberation at that one time. So before we get to the landlord's testimony, we will turn to our legal counsel for a staff report.
Thank you very much. Again, my name is Kellen Martz, legal counsel to the Rent Stabilization Commission. Before you is D-5006 at 1125 North Vista Street. This appeal is from both parties. In this matter, the application for a rent reduction was filed in January of 2025. The tenants have lived there since 2015. The hearing examiner in this matter found that they were entitled to a rent reduction for some of their requests, but denied others. The landlord and tenant both argue that the decision is clearly in error, while the tenant argues that the decision is not reasonably supported by the findings or evidence in the record. In their application, the tenants sought a rent reduction for 5 issues: a storage shed, a parking space, a ceiling fan and light fixture, heat in the unit, and lack of a property maintenance or gardener. The hearing before the hearing examiner was conducted in February of 2025, and both parties appeared before the hearing examiner. In March of 2025, a decision was issued granting a rent reduction for 3 of the issues: the ceiling fan light fixture, $15, the heat in the unit, $89, and the gardener issue, $23, and that was deemed a common area issue. The owner filed the first appeal, the tenant filed the second appeal. Tenant argues that the hearing examiner erred in thinking that the storage shed at issue here is the same storage issue in the case you heard previously tonight, D-4987. Tenant also argues that a rent reduction should have been awarded for parking, and that this was written in their estoppel certificate. Landlord argues that the storage shed remains in place and it is not part of their lease. Landlord also argues that parking was not mentioned in their lease and that the tenant is at fault for not allowing access to their unit to conduct repairs on the fan light fixture and to treat for pests and rodents. And then lastly, landlord argues that they do provide maintenance and gardening services. And so the question before you tonight is there substantial evidence in the record regarding the storage shed, the parking space, the ceiling fan light, the lack of heat, and the gardener and maintenance? Staff believes that the hearing examiner partially erred and was partially correct, but finds that there is substantial evidence in the record to support the decision as to the parking, ceiling fan, heat, and maintenance gardening issue. Staff finds that the hearing examiner erred as to the storage shed and also as to the reason why the parking space should be denied for a rent reduction. For the storage shed, staff recommends reversing the decision and issuing a rent reduction in the amount of $150. The hearing examiner erred in thinking that this was the same issue. Staff believes that these are two distinct spaces on the property. One is the garage, which you addressed previously, and one is a freestanding storage shed. And staff recommends $150 rent reduction given the size of the storage shed, the market value of a similar storage, and the impact it has on the tenants. Staff recommends the commission affirm the hearing examiner's decision for the parking, which was to deny the reduction, but to not adopt the findings made by the hearing examiner. This matter was addressed in D-4987 and should not have been considered in this review. And in D-4987, the patio and parking were lumped together, so that was one issue together. As to the ceiling fan and light fixture, this comes down to whether there's substantial evidence in the record. Staff believes that there is. And if there is an issue with blocking access, a compliance determination is the best route to go. That same reasoning applies to lack of heat in the unit. And then for the lack of property maintenance or gardener, staff recommends the commission affirm the hearing examiner's decision that there is substantial evidence in the record, and if there is a gardener provided, then a compliance determination request is the most appropriate remedy for that issue. So in this matter, staff recommends that the commission affirm in part and reverse in part the hearing examiner's decision consistent with the staff report and the recommendations, and adopt RSC Resolution 25-683. That concludes my report.
Thank you very much. I have a question. You mentioned compliance determination, and those of us who hear this on a regular basis have some concept of that. Could you just enlighten us, or not us, but the public in general, about a compliance determination and how that differs from an appeal?
Yes. So a compliance determination is where a rent reduction was issued and the landlord believes that they have returned that service and should have that rent reduction erased. And so for example, this case for a gardener, if there is a gardener either provided or they hire one after the fact and now say, I'm providing the service that was allegedly taken away, they can apply to the city and the city will review that request and potentially return that rent reduction to the landlord to bring it back to what the rent was prior.
Thank you. And that also goes for trying to remedy issues and being denied the opportunity to do that by the tenant. They can file for compliance determination with that being the reasoning as well.
Correct. A hearing examiner could do a compliance determination and find that the rent will be restored, not because the issue was resolved, but because the tenant was at fault for blocking or not allowing access.
And I'm not predetermining how the hearing examiner
Correct.
would make those decisions, but
That's
that
a
would be the
general
process.
statement.
We wouldn't hear evidence that it's been resolved subsequent to the hearing examiner. We determine whether it was what the condition was at the time the hearing examiner heard the case.
Correct.
Thank you. Any additional questions of staff at this time? And I appreciate that. I know that we deal with that on a regular basis, but oftentimes tenants and landlords
That's a good point.
don't hear it as often as we do. Thank you. So in this case, the first appeal was filed by the landlord, and so we will go through the same process. Name, city of residence, how you'd like your time divided. And you can begin.
Brian Tannenbaum speaking on behalf of management for 1125 North Vista Street. So we will be filing for the compliance. We will submit the paperwork, and we'll ask the inspector to come out and she will see the light fixture and fan is installed. It was removed by the previous, some previous property owner. Fabian will accept that. I'm sure she will accept that. The other two, we have spent some significant money for the air conditioning system, so we will have it inspected. And the other thing, gardening, we have a gardener, so we will apply for compliance. On most of the issues, we will go for compliance, ask for compliance. In response to the shed, is that an issue of this hearing, the shed? This is a picture of the shed. The shed is still there, but it's empty. Previously, this is a driveway for cars, and Fabian had a lot of her personal possessions, tables there in the parking lot. This shed sits on two spots that could be parking spaces, but that would be a reduction of services if we remove the shed. So the shed is there, but we'll ask the compliance officer, we'll submit in the paperwork to the compliance officer to come and look at the shed and say that the shed is there. Okay, we will ask for that. And we will go along with that approach. There was an issue mentioned by Ms. Copeland, I wanted to respond to, that there was estoppel, but it was not signed by any previous owner. That's the estoppel that we have a copy of. Maybe there is a signed one, but the one that we have is just not signed. We're going to go that route. We are going to go that route. So we still have that option to us, and we will pursue it. But to come and tell me no light fixture when there's a light fixture, told me day is not night, night is not day. Told me a contract has no value in West Hollywood. Well, if it applies to the landlord, it has no value, but it favors the tenant, it's okay. But it's okay because we can solve a lot of these things with compliance. We have the paperwork, and we will follow that route. Okay, we are asking for access to get to the attic in her apartment to service. We have had exterminators there. They want to go into her attic, and we need a ruling that allows access to repair things in the attic. That's it. Thank you.
Thank you. How much time does the landlord have remaining?
2 minutes and 32 seconds.
Did any of my colleagues have questions for the landlord at this time? The vice chair has a question for you, Mr. Donovan.
On the storage shed itself, there were some pictures in the record that it was empty, and I understood you tonight to say that it's currently empty. I guess my question is the tenant allowed to use the storage shed? Or are you just keeping it empty?
In accordance with West Hollywood law, she's entitled to the usage by West Hollywood's reasoning of that she's entitled to the usage. So she could use it because we'll have the compliance officer come out, say the shed is there, and she'll put her personal possessions there. There's no limitation on what she could put in. It could be fire hazard. It could be her possessions because you say she's entitled.
Well, I don't know about your last comment about those types of hazards being allowed, but I'm just questioning, there's nothing preventing her currently from using the shed. That's your position?
Would you allow her to use the shed?
I would allow it, but I would like to inspect it because, I want to make sure what's in it.
What do you mean you would allow it, but you want to inspect it?
Because there was a lot of hazardous stuff like old paint. I want to make sure my building doesn't go on fire. That's the reason.
So you haven't been allowing it, but because you want to have a
when
discretion about what's in there?
When I told them to open it, I wanted to know what's in the shed. When they opened it, I saw a lot of stuff that can go on fire. So I told them this is dangerous. You can, it's hazardous. It's paint. It's old paint.
Okay. All right. I think that's enough for me right now.
Thank you. Commissioner Goldman, you had a question?
Yeah, similar to my colleague, but I'm wondering, was there a key to the shed? Is it locked?
She had the lock. It's not locked. It's open.
Okay, so that's it.
She had a lock and she took the lock. I didn't touch anything.
Okay, so you haven't put a lock in or
I didn't touch anything. I didn't have a lock. I didn't touch anything.
Okay, thank you.
Thank you.
Well, I just have one follow-up. There was notice to remove everything from the shed?
Nope.
We have those documents here that were provided at the
Because it
hearing?
was mostly paint.
Okay, so there was a notice to remove stuff?
The paint.
And there's never been any notice that now you can put stuff back in as long as it's not paint or as long as there's not been any notice at all?
No.
Okay, thank you very much. That's my question. Any others? Thank you very much. We
All right.
appreciate your time. We will now turn to Fabian. Are you? Okay, I didn't know if it was you or Brent this time, but you will have 5 minutes. You cannot divide your time.
Can we split the few
You can share the
minutes?
time,
Because
yes.
I want to respond to everything I heard so far from the landlord. This is absolutely ridiculous. Okay, we don't have paint. We never had paint or whatever harmful in a shade. The shade, as we considered it to be, Brent and I, when we first moved in 2015, basically the original landlord gave us the shed as an extension of our unit. Because our unit is small, and we told him basically, you know what, it's kind of small for us. He said, listen, okay, you can use the shade, and that will be part of your unit. And I say, okay, then okay, so we rented the place. Okay, so since 2015, we had the shade because we had a lot of furniture and I don't know where the paint is coming from. Now, when the new landlord came in, I mean, actually acquired the property, he asked us to remove that shade. And I sent him so many emails, trying to convince him to leave us alone, to leave that shade alone. It belonged to us all this time. I even mentioned to him, okay, you know what? And for him to leave us alone, I said to him, okay, well, hey, you know what? It's behind our building. Right now, we do not have a car. Okay, so it could be, you could view it as if it was our parking. Not that it was, but just as far as, okay, to leave us alone.
I need you to use the microphone so that anyone at home can listen, can hear
Yeah,
you. Thank you.
okay. So anyway, he never left us alone. So I was basically telling him, you know, leave us alone. You know, I emailed him, say, there is nothing hazardous, you know, versus what you have been putting in a garage. You know, he put like some tank, you know, gas tank and things that I took picture of anyway. But regardless of that, that was a garage and we dealt with it. But as far as the shed, there was nothing hazardous. There was some pet porter that I was storing, you know, things like this, like a table or a little item, and you have picture of it. I mean, I presented a picture of it. Now, as far as the shed, this is very interesting, you know, because it was so, even so I told him, you know, I said to him, you know, so many emails, keep the shed, leave us alone. And now he will be willing to give it back to us. It's like we already got rid of most of what was inside. You know, either we, you know, because we couldn't keep it in our apartment being too small. That's why we had the shed in the first place. You know, that the original landlord let us have. By the way, it is not our shade. And I know that the landlord has been complaining about us not removing the structure itself. We are not entitled, we cannot remove the structure because it always belonged on the property since day one. And we don't have the right to remove anything which belonged to the property. I told the landlord, you know, he wanted us to remove it by November 22, I believe that was the deadline. And we complied with that deadline. We removed everything. And it was a lot of work, you know. And we removed everything. And since then, the shed is still sitting there. When he called it to be, when he said, no, I need the space for parking. It's a nuisance. You cannot have it. And why is it still sitting there? And honestly, now the door of the shed are broken. You know, I hope he's not thinking that we can take it back because, you know, I mean, for a few months now, it's been like totally like neglected because the door is off. Their car have been running on a door. I mean, I don't want that shade anymore. What for? He asked us to remove everything. But anyway, that's besides the point because as far as the shed, that's what, you know, I just wanted to tell you. No, I don't know if he wants to say anything else, but that's regarding the shade. Oh, yeah, the gardener. No, there is no gardener, okay? So far, I have been the one, I mean, for many years now, taking care of the property. Okay, sweeping and, a gardener came twice to trim some tree. twice, only twice, okay, during all the time he's been owning the property. There is still no gardener. I'm the one doing the sweeping and everything else. But it's okay, you know, but just to let you know. Oh, and as far as the fan, yes, they came in and they did it. So now we are okay with the fan. Okay, so that's that's cared for in a living room. And there is, the entry. Okay, the entry to the attic, that's a big issue. They have been
That's your time.
Thank you. Your time has expired.
Okay.
And so thank you for your time. Are there any questions of the tenant at this time? Seeing none, we will go back. You will now have your time for rebuttal, should you choose. Remind me of how much time the landlord has here. I'm sorry, Ms.
2
Martin.
minutes and 32 seconds.
Okay, thank you.
I have pictures that everything is clean. West Hollywood came out for inspections 3 times. I have emails from Inspector Melissa, Code Enforcement. I've been in touch with her like at least 100 times within the past year. We're friends now. The city already knows them. They're very famous, okay? So anything happens, they run to the city. The city came out there many times, okay? I got plenty of emails, plenty of evidence. Everything has been fixed. Like he said, my colleague, if we have to go back and get an inspector there, we will. There's no issues. Everything is fixed. We just need access to that attic. And we put about 7 to 20 notices to send our people there, and I have emails, evidence. She refused entry. You know, I mean, West Hollywood told me what to do. I have emails. If you guys want to see them, I mean, I'm sure you guys have the records. That's it.
Thank you. Any questions of the landlord this time? Okay. So that concludes the testimony for the first appeal, but we now have the tenant's appeal. And so, are we good? Okay. So we would just reverse order here, where the tenant would have 5 minutes that they can divide, and then the landlord would have 5 minutes in the middle. If you have anything, again, these are generally the same issues. You don't have to use the full 5 minutes, but you certainly have that available to you. So please introduce yourself by name, city of residence, and how you would like to divide your time.
Good evening. Brent Winter, tenant at 1125 North Vista Street. We will be dividing our time for 2.5 minutes, and Fabienne will then follow.
Thank you. Ms. Thornton will let you know when that 2.5 minutes is expired.
Thank you.
Please proceed. You can lift that up too, so you don't have to.
Okay. Thank you so much. Acknowledging Harvey Milk Day, I very much appreciate and applaud the commission for affirming the decisions so far in our appeals and our rent reduction cases. I do want to make it clear that in contrast to what the landlord has been suggesting, we have never, as tenants, denied access to our unit ever to allow for repairs within our unit. Just this week, actually, we got a defective entry of notice that did not possess any rationale for the entry. And the next day, somebody did come by. Fabienne was at home, had a conversation with the young man, and then did allow him in. And he documented certain deficiencies within the unit that continue to exist. Just to let everybody know, and we're on the record, we do not deny access to our unit for repairs within the unit. What's been happening is access to the common area attic space, where the rodents have been collecting and being a nuisance. Also infiltrating the ducts of our central heating and air system. And the repairs were effected back in October, but because they did not remove the rat situation, the ducts became compromised again, and we are currently without heat, and that is why we enjoyed a rent reduction for the heat in our unit. That's enough said about that. Yeah, the access as it is, it's above the driveway adjacent to the structure, to the premises, and anybody who has had need to get into the attic does not need to go through our unit to do so. It would be like trying to access the roof, common area access, through our chimney. Regarding the parking, we're kind of confused as to how the decision in 5006 refers to a decision made in 4987.
That's your time.
Okay.
2.5 minutes have expired, so you have 5 minutes. You can continue to go, but it will come off of your rebuttal.
Take 1 more minute if you
Regarding the parking, we just don't understand how the decision is made to not provide a rent reduction, so we are going to presume that we indeed do have a parking space at our as part of our tenancy. And I reserve the balance of our time.
Thank you. How much time does Mr. Winter have remaining?
2 minutes and 20 seconds.
Okay. Let's see if there are any questions. I think the Vice Chair has a question.
Just one question. There's an issue on the appeal about deprivation of heat. And I think I understood you to explain, which I was missing from the record. Is that related to the attic issue and is there heat currently in the apartment?
Not at this time.
Okay.
The system is operational. However, due to the fact that rodents have infiltrated the ducts in that area of the common area attic space, we have taped up all of the vents in the ceiling in order to avoid contamination by the rats and the droppings, etc.
All right, that helps explain, because in the appeal tonight, there wasn't direct testimony about the rodent issue, but now I understand how that's related to the heating issue and the ducting issue.
Okay, I'm
Thank you.
glad to clarify that.
Thank you. Any additional questions of the tenant at this time? Seeing none, you will have your 2 minutes and 20 seconds remaining for rebuttal, should you choose to take it. We'll turn to the landlord for their testimony to the tenant's appeal.
Ryan Tannenbaum speaking. Numerous times the exterminator has been out to the property, and the exterminator has said he needs the way to the attic is through the closet, and they refuse to supply access through the closet. He cannot crawl through an entry on the outside of the building. He needs access through the closet, which they refuse. We have given them numerous requests. We have stacks of papers which we submitted in the previous hearing showing where we gave them notice for access, and that was included and given at a previous hearing. One other thing, the heating. We spent a lot of money for the heating unit, and we have proof of that. So we have attempted and tried to give them heating. We see them as troublesome people with a history, even from the previous owner. We have documentation of a previous hearing where they make similar complaints. Not exact same claims, but similar complaints, always seeking reduction. Okay. Sean, you want to say something, or you want to let it go? Okay, thank you.
Thank you. Do we have any questions of the landlord?
You have questions for me? You have questions?
I'm seeing none. Thank you, though. We will now turn back to you, Mr. Winter, for either one of you for your 2 minutes and 20 second rebuttal.
Okay, they do have an entry to the attic. The entry, well, initially they wanted to enter our apartment from the closet. They were saying that they were making up the fact that it is a 1926 building. So there is no firewall. It's an open space. That's where the ducts are located to our central unit system. Each time there was a need to fix something inside the attic or even to just go inside the attic. It has always, the entry has always been near the driveway, above the driveway, there is an opening that people, I mean, that's the way they did it back in October when they actually changed the ducts because there was a rat infestation. That's how his own crew used the entry from the attic. From the outside, never from our closet. You know, it has never been an option. Since the time we've been living there for 10 years, it's never been an option. Furthermore, it is very hazardous to our health. And there is a notice that they gave us asking us to remove everything from our storage, from the closet, because there is debris and all type of things. I mean, I don't know if you've looked at those big ducts, and they are expecting that to go through our closet. Furthermore, we can't, because I already got like bit by mites, by rat mites, once we discovered that the rat, because they didn't take care of the situation prior of changing the ducts, which were there, which was already contaminated with rodent. So what they did, they changed the ducts, and they didn't take care of the rodent infestation. Guess what? And I told them, I warned them, you know, maybe it'd be a good idea to take care of the rodent before changing the ducts, replacing the ducts. They didn't do that. They just replaced the ducts. Of course, the rodent came back, and they infiltrated again. And during that, for the short period of time between they replaced the ducts and we were able to use again heat, I was like, it was fine. I was very happy we had heat again.
That's your time.
Okay.
Thank you.
The fact is that after we use the heat, I was starting getting bites because
Your time has expired.
Yeah. Okay.
Thank you.
Right, so.
Let me just ask you. We have evidence here of notice of emergency entry. The one I'm looking at for my colleagues is page 403 of the staff report of the packet. But it says, Dear Fabian and Brent, and it's signed by Lux Management, but it says they're going to access your unit on February 18th. And there's a Post-it note attached to it said that it was posted on the front of your unit on February 15th. So you didn't let them in on the February 18th, or?
February 18th?
Yeah, like I'm using this as an example of the landlord giving notice that they were going to be coming.
Yeah. They gave us plenty of notices trying to access the attics through our unit, and therefore, you know, compromising our environment. I mean, jeopardizing our environment, and also it's not necessary.
Okay.
Why do you want?
Because your time has expired, I need to keep you directly to the question.
Yeah,
My question is, did you let them in at that time or not?
If we let them
Whether
in,
there was rationale for them to come or not, my question is
we
just...
let them in. Each time they needed to come in, they came in. We've never, we just refused. I mean, not even refused. We thought it was not necessary. It's not necessary. It's just purely retaliation to want to go through our unit to access the attic.
Thank you. I think you've answered my question.
That's it.
They don't need our authorization to go into the attic.
No, I'm asking if you gave them access to, they requested access to your
We have
unit?
never denied access to our unit.
Okay.
To the ownership.
Okay.
Ever.
Are there any additional questions at this time? Seeing none, we thank you for your time, and we will turn. I didn't ask for public comment, but our secretary would let me know if there was.
I would let you know there's no public comment.
Thank you, Ms. Thornton. Any questions of staff before we move into deliberations? I do. Yeah, Vice Chair Rory.
I apologize because this one is so issue specific, so I was wondering if you could just regroup for me. We've closed the hearing, public hearing part.
Yes, all public hearing is closed at this time.
So if we could just go through the items on the appeal and then what the hearing examiner initially recommended and then what staff is now recommending, so I can make sure I understand everything correctly. But that's my general request. For example, for the storage shed, there was previously, the hearing examiner had some confusion about whether that was part of the garage, which we previously looked at in the last appeal, and now we're saying, no, the shed is different from the garage, and we're recommending staff is recommending $150 rent reduction for the shed itself. That's the procedural layup for the shed, correct?
That is correct, yes.
Okay, and for the parking space, this one I'm kind of foggy on, That issue was part of a previous appeal, so there should be no rent reduction for that issue because it was already resolved in a previous appeal.
Correct. And the procedural difference there is that staff is saying it was in a prior appeal, and so that's the reason for the denial, whereas the hearing examiner made a different finding that staff doesn't agree with. So it's the same denial, switching the reasoning.
Okay. On the ceiling fan issue, there was a rent reduction, and the staff is recommending to approve on the rent reduction, subject to any landlord right for a compliance determination.
Correct.
And on the deprivation of heat, there was a rent reduction, and staff is recommending that that be affirmed.
Correct.
Subject to any rights of compliance determination.
Correct.
And on the gardener, there was a reduction, and staff is recommending that that be affirmed, subject to any rights for compliance determination.
That is correct.
Okay. Thank you.
You're very welcome.
Okay.
Yeah, this is a complicated one. Thank you for
Yeah,
bringing
and
that
I don't
up,
think
Vice
there were
Chair.
any other issues that, the attic issues that we kept hearing about is related to the heat, which I cleared up earlier, so I was a little confused about that.
Correct.
Okay.
Thank you. Additional questions of staff? Then who would like to begin deliberations? Any one of you, yeah. I try to go last as chair.
All right, Chair,
possible.
thank you. This appeal to me is very clear. Although I see the relationship between the tenant and the landlord, sadly, is not that good. That would just allow some sort of a compromise between them to arrange something. But that's why I'm just going to go based on what we have before us, clearly. And there was a lot of things were said that are completely irrelevant. I'm pretty much in full agreement with the staff's recommendation, affirming in part and reversing in part the decision of the hearing examiner. And what I'm going to say is that to the landlord, if for those issues that you're ready to file for compliance determination, you should do it as soon as possible. As for the other things, as I said, most of the things that were comments were made were irrelevant, and I would just say that again, I'm in support of the staff's recommendation. Thank you.
Commissioner Goldman.
Yeah, so this one, there were a lot of moving parts to, but yeah, I agree with my colleague that much of what was said is not really for the commission to weigh in on. They were irrelevant to what we have before us. And I think there is the evidence to support staff's recommendation. It sounds like from a lot of what the landlord was saying, they need to file for compliance determination if they feel that they have addressed those issues. So I also support adopting the resolution as staff recommends.
Thank you. Commissioner Copeland, would you like to go next? Or Vice Chair, either one of you.
You know, I think I'm happy to hear the ceiling fan issue got resolved, and I did hear an undercurrent of the landlord trying to do things to improve since they've become the owner, and I appreciated that and acknowledged that and would encourage that to continue. It does sound like there's still an issue with the heating, so clearly there's still some more work to be done. I think the shed issue is one that I would encourage the parties to work out. But based on the evidence that's in front of us right now, it's clear the shed existed on the property when the tenant began their tenancy. That was part of what they rented the property so that they could have use of that shed. Whatever the landlord thinks about the shed now, it doesn't need to be in the lease. It's a liberal standard for a housing service. It was clearly a service. It was taken away, and it's up to the parties then about whether that service is going to be restored or whether there will be a rent reduction. But I'll leave that to future discussions between the parties. I just think in terms of what staff is recommending, there was a housing service. It was taken away, and so there is under the regulation a rent reduction that has to go with that. I think no one's talked about, but the interest of thoroughness, the 150 amount I'm comfortable with as well. It's proportional to the garage storage area, which seemed to have been a much larger area, so it's not like it's more than that. And there was evidence in the record about how much rental space costs in the surrounding areas. So I think, unless I hear other comments from commissioners, I'm comfortable with that amount. And on the parking space issue, I'm not sure why this. I understand what the staff is saying. I don't know the details, but on the evidence in front of us, they're saying it was part of a previous appeal. I have nothing before me saying it wasn't part of a previous appeal, so I'm going to adopt their recommendation on the parking issue as well, even if that cuts against the tenant here, because our job is to make sure that what happened in front of the hearing examiner was correct, and if there were any errors, staff's recommending the adjustments on the shed, and I'm comfortable proceeding on that, but otherwise I'm going to support what the hearing examiner said.
Thank you, Vice Chair Roy. Commissioner Copeland.
Thank you, Chair. I won't belabor the facts that my fellow commissioners have already stated, but I do agree with staff that the commission should affirm in part and reverse in part the hearing examiner's decision. I think based on the relevant testimony tonight on these items, a lot of this could be, perhaps it will change with the compliance determination, but as that is not in the record and that has not been done, we have to go on the evidence that we have right now. So I don't think that $150 is unreasonable given the replacement cost for storage, and as well as, it's certainly less convenient to have to go elsewhere to store your belongings. So a compliance determination could return that as long as it hasn't been damaged, meanwhile, or doors removed or anything like that was mentioned. Same with the ceiling fan fixture and the heat issue, rodent issue. That is also something a compliance determination could come out and say that is the access being, is there access to it that they can use, and if not, if it has to go through the unit and they're refusing it, that's something that would determine as well. The maintenance and gardening, at some point, gardening service was provided during the tenancy, and then the tenant testified it was discontinued in 2019. But when a new owner takes over a property, the fact that the previous owner may not have been in compliance with some sort of maintenance or something doesn't give them a license to continue to do so. That that still needs to be made good, in other words. So I agree with staff's recommendation and also my fellow commissioners that a lot of this could be solved with compliance determinations, but meanwhile, the reductions are valid. That's it for me, Chair. Thank you.
Thank you, Commissioner Copeland. Yeah, so everyone understands that when there's a compliance determination filed with the city, the tenant will have the opportunity to object if they choose to. It sounds like tonight, and there's video of this that'll be online, that they agreed that the ceiling fan is resolved. So I would be surprised if there's any objection to that one. And it sounds like tonight that the access to the storage shed will be restored. So it would be hard, that's what I heard here, is that will be restored and that they have the right to use that. So it would be pretty hard to object to that if that's how that actually proceeds. So, when somebody applies, for a landlord applies for a compliance determination, the tenant will have the opportunity to object, and then the hearing examiner can choose whether to whether to have a hearing or not, but then they will make a determination as to whether these things have been applied. And I give that background because oftentimes I find that people come before the Rent Stabilization Commission and ask us, like, look, we got a reduction, but we've since done the work, so please get rid of it. And we really can't do that. The way we are forced to look at this is, did the hearing examiner make the right decision when they had this in front of them? And that's really the only question in front of us tonight. Did that hearing examiner make a reasonable decision with the evidence that they had? And so with that in mind, I agree with my colleagues. And it's unfortunate sometimes when it sounds like the work's been done that we have to say, yeah, but you have to go file yet another thing. And so that's kind of why I give that bit of explanation is that's just beyond what our authority is tonight. I also want to put out there that ultimately, and I've heard my colleagues say this in the past, oftentimes Commissioner Kerpes, who's not here this evening, but we really, at the end of the day, want our landlords and tenants to get along as much as possible because it's people's living situation, it's people's business situation, and it's unfortunate when that's not the case, and it feels like that's the case here. I would say that the city has an excellent mediation program, and when things come up in the future, it would be great if maybe it's pie in the sky. Maybe I'm being Pollyanna here, but I would love if this relationship could get better because these sorts of things can be very acrimonious, and it would be great if the tenants could have a great living situation that's comfortable, and the landlord can make an investment and return on their investment. And I mean, at the end of the day, that's what we want on both sides. Speaking with really broad terms. So with that, I agree with my colleagues that the staff's recommendation is the appropriate resolution here and would entertain a motion to that effect, or a motion to any effect, but I think that's where we're at.
Chair, I can make a motion to adopt resolution RSC 25-6883, a resolution of the Rent Stabilization Commission of the City of West Hollywood affirming in part and reversing in part the hearing examiner's decision as to application number D5006.
Is there a second?
I'll second.
Commissioner Goldman seconds. Ms. Thornton, can we have a roll call, please?
Commissioner Copeland,
Aye.
Commissioner Goldman,
Aye.
Commissioner Topshin,
Aye.
Vice Chair Rory,
Aye.
Chair Bass.
Aye. That motion carries unanimously. If the parties have any further questions, you can reach out to the Rent Stabilization Commission or Division at 323-848-6450 by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. With this, I would like to ask if we can take a 10-minute recess.
Yes, please.
And we will be back at, I think, 8:43. Thank you. Randy, you good? Okay. Okay, I will call the meeting back to order. I appreciate your patience. We move on to our final appeal for the evening, which is new parties, a new address. The address is 1035 North Hayworth Avenue, apartment 110, and the appeal is D4989, and we will turn to Mr. Martz for a staff report. Thank you.
Thank you very much. My name is Kellen Martz, legal counsel to the Rent Stabilization Commission. As noted, this is D-4989. The property address is 1035 North Hayworth Avenue, number 110. The matter before you tonight is a maximum allowable rent, or MAR, and rent overcharge matter. The tenant in this case has lived at the property since 2004. The tenant filed their MAR and rent reduction application in March of 2025. The hearing examiner found that the MAR was set at $1,200 and that the tenant was owed a rent refund for rent overcharges in the amount of $238.47. The tenant has appealed, arguing that he did not know he had to provide additional records to support this claim. A decision was issued in February of 2025 granting the MAR determination and rent refund request. It found that the landlord had issued 2 rent increases within a 12-month period, which is a violation of the RSO. Those 2 notices were dated July 1 and August 1, 2013. And then the second notice also included a pass-through fee, which is improper. I'll defer to the staff report for the math. Lawyers don't like math, so it's said better there. But it does come out to a overcharge of $238.47 for 5 different months. And so the question before you tonight is there substantial evidence in the record supporting the hearing examiner's decision regarding the MAR and rent overcharge matters? Staff believes that there is substantial evidence in the record to support the decision. Here, the decision was supported by the evidence presented at the time. The record was left open to submit additional information. And so there is substantial evidence of the record, and the decision is not in error. The tenant may have additional civil remedies, such as small claims court, if there are other issues or other evidence to provide. But the basis before the hearing examiner and before you now is just with what was provided to the hearing examiner. No additional new evidence can be considered. And so on that basis, staff recommends that the commission affirm the hearing examiner's decision and adopt resolution RSC 25-684. Thank you.
Thank you. I see our vice chair reaching for his button. So you have a question?
Can you remind me of the rule for how far back the hearing examiner can go for a rent credit in the circumstance where they've determined that there was a MAR and there was rent in excess of the MAR? And the recent rule change on that, which I understood to be that you could go back 4 years from the date of the application, not to the beginning of the tenancy. But could you remind me of that rule change?
Yeah, so it's 3 years is the statute of limitations if it is related to a registration not being filed. So that's this case. So it's 3 years from when they registered it. So let's see if I put this into this actual staff report.
They re-registered, and that was my next question on the timeline here, because the tenancy starts in '04. There's some rent, and the evidence so far is in the record was it wasn't registered when the tenancy began in '04. Then there were a couple of rent increases in 2013. And then there was a registration in 2015, and then there was an application more recently in 2025. So can you help clarify for me, when the application is made in 2025, or late 24, the hearing's in 25, they go back to 2015 when the registration was officially filed, and they can look 3 years back from then?
That is correct, yes.
Okay. And here, the only months where there was evidence of rent that was paid in excess of the MAR we're limited, and that's why it's a $238 amount and not multiple months within that 3-year period.
That is right.
Thank you. Any additional questions? Commissioner Copeland?
Thank you for asking that one, Vice Chair. Maybe if you could expand on that for just a little bit for me. I'm looking at the dates and the amounts that were awarded, and the last one says 8/24, August of 2024, for $60.88. So I was a little confused as well about how the determination where the 3 years starts from.
On that one, I'll look at the original decision and let you know for that one specifically. That is
Okay, because there's several 13s and then 15 and then 2024. I didn't know. I was a little confused about when they go back as well. Also, what's the difference between this and, say, your normal rent reduction for a service that's removed? Is a claim for rent overcharges only allowed to be filed once, rather than they couldn't come back, say, with some cases we have a 6-month waiting period. Is that relevant for this, or is it just once and that's it?
so. Whatever they filed for in their original request would be a one and done. And so, because the hearing examiner made a decision about what the MAR and the rent overcharges were for whatever period was requested in the original application.
Okay, thank you, appreciate it. That's it for me, Chair, right now.
Thank you. Commissioner Goldman?
So because I'm like my colleagues, and thank you for those questions, I'm looking at the dates and everything. I'm wondering, in order for a hearing examiner to make a decision, do they have to have all of that evidence in terms of like bank ledgers and all of that? I just want to clarify that.
Yes, there could be other ways, but just like in a housing service case, you provide what's the best evidence available. Bank statements are typically how it's done. There could be other ways, but that's generally how it's handled in a MAR and rent overcharge case.
Okay, thank you.
You're welcome.
Thank you. Any additional questions of staff at this time? Commissioner Thompson?
To follow up on Commissioner Goldman's question, so if there is additional proof of payments, and I believe the tenant has additional proof of payments, but those were not presented at the hearing. So how the tenant can pursue the reimbursement for those months that are not included in this chart, in this table?
The only matter before you is what's in the record, and there could be other ways, other court processes, but before you is just this limited scope.
So we're not going to even touch that. Okay.
Correct.
All right. Thank you.
Thank you very much. So we will proceed with this appeal like we did the others, and that the tenant, Mr. Palayo, I believe, filed this appeal, so you will have 5 minutes to speak. You can divide that time. We would ask you just to let us know up front so our secretary can let you know when your time has expired. So when you start, just state your name, city of residence, and how you would like to divide your time.
Okay. My name is Victor Palayo, and I live in West Hollywood, California. And I can just use the whole time. I just have a brief statement.
Thank you. Please proceed.
So I'm not here to argue against the hearing examiner's professionalism or process. I'm here to respectfully ask that the case is remanded so that the full rent payment history I provided with my appeal can be properly reviewed. At the time of the original hearing, I understood that he needed a proof of the before, like the date before the rent was increased and after, just to establish a timeline. So those are the only two checks that I provided. You know, the before I was paying this much, and then after the increase was done, I was paying more. I thought that's all he needed, because obviously I'm still living there, so I'm paying the higher rent since then. So that's the only reason why I guess I misunderstood what he needed, so I only provided enough for the timeline and not a full history. But I do have, you know, more pay stubs of the checks. So I've lived there for 20 years and basically overpaid more than 10 years, and all I'm getting back is $200. So that's it. I just wanted it to be fair.
Thank you. Is that the end of your statement?
Yeah.
Okay. How much time remains?
3 minutes and 37 seconds.
Thank you. So you will have that for rebuttal should you choose to take it, but I'll turn to my colleagues now to see if you have questions of Mr. Paleo.
Just to clarify, at the hearing, were you explained in a way or told that, additional evidence of payment was necessary?
Well, they asked us if we had like a ledger of rent or whatever, and I didn't because I pay with money orders, so I have a stack of papers, and I told them I could find the proof of when the rent changed, and that's what I did. I only brought, what I was paying before the change and after, and I just assumed that, given that I'm still living there, it was implied that the rent was paid, and because I haven't been evicted or whatever, so clearly I've been paying that amount since. So I just assumed it was implied, and I didn't know that he needed a full.
Okay, all right,
library.
thank you.
Thank you. Additional questions of the tenant? Seeing none, thank you for your time. You will have the opportunity for rebuttal.
Thank you.
And now we will turn to the landlord. I have James.
Chair,
Yes.
could we actually do public comment?
Okay, that would be
Thank you.
great. Yes, thank you for the reminder.
Of course.
So we will ask if there's public comment at this time.
Yes, there's public comment. Brian
Okay.
Shuley?
And again, your name, city of residence, and you will have 3 minutes.
Yeah, I'll keep this short. My name's Brian Shuley. I live in West Hollywood. I'm the new manager of the property that's under question tonight for this appeal. I'm merely just showing up not to take either side because I really was not involved in any of this. This happened, significant amount of time before I took over this property, which was just last week. But I just wanted to come out of respect for the process, the commission, and both parties involved. And I forward myself to any questions or concerns or any knowledge that I need to be aware of for moving forward. And that's all. Thank you.
Thank you so much for being here tonight. It means a lot. Now we will move on to the landlord, Mr. Leovi. Again, correct me, please.
James Leovi from Los Angeles.
Okay, and you will have 5 minutes, not divisible. Please
Yes,
proceed.
thank you, Adam, Agassi, Rena, Frank, and Kimberly for giving me this chance to talk. Mr. Paleo, at the hearing, in my opinion, was it was no question that he understood what he had to bring. And whatever he had to bring, I would have been happy to pay back whatever was due owed. So I don't think anything else should be heard in the hearing because everything should be settled. I was a little confused with Kimberly, with your question on the dates of how far back that you asked him. Can you let me know what it was?
Generally don't do back and forth here unless the commissioner asks questions, just as a matter of protocol. If the commission has questions of you, they will ask that at that time.
Oh, okay.
Yeah.
Do I get a chance to come back at a speech?
You will
or do
not
I-
have any
I
rebuttal
have to
time.
use-
You have to
I
use all of your 5 minutes
I
now.
have to
Yeah.
use the 5
The
minutes.
same as the previous hearings.
That's this time. Okay, Mr. Paleo did file a hearing application. On his hearing application, he brought those questions into the rent increases. He also had a 3-day notice was a wrong amount due. Were you guys able to see that in the hearing application?
Again, we don't do back and forth, but I will tell you we have the entire record that the hearing examiner considered.
Yeah, it does say 3-day notice. 3-day notice has wrong amount due. All right, well, I guess that settles up. If we don't go back and forth, it's kind of hard to do that. But I think we should stand by he's had his chance. I was there, I put the time in. I don't feel I should be back here, and I think we should move on. Thank you.
Appreciate your time. Do any of the commissioners have questions? I do have one, Mr. Yes.
Why'd you let me go back?
Sorry, I was looking down at my notes, so I didn't see you starting to walk away.
Yeah.
My question is, do you have a full ledger of the amounts paid?
You know, you only go back to so far, and he's going back to 2012. That's ridiculous. My mom was alive then.
So you do have a ledger, and did you provide that?
I provided whatever the hearing examiner asked me to do that I had.
Thank you. Any additional questions? Okay, now we'll turn back to Mr. Palaio. You will have just over 3.5 minutes for rebuttal, should you choose to take it. You're waiving that? Yeah. Okay. Any questions of the tenant before we close the public hearing? Okay. Then we will close the public hearing and the testimony, and we will turn now to questions of staff, questions of staff by the commissioners. Commissioner Augustine.
Thank you, Chair. Just a quick clarification for me to understand. At the hearing, if the tenant realized that additional documents were needed, was there record kept open after the hearing for a few, 10 days or something, or after the hearing the record is closed?
Yes, the record was left open. And if you give me 1 second, I can tell you how long that was. It was kept open until January 17th.
January 17th.
And the hearing took place on the 16th. So it was for an extra day.
Extra day. Okay. So technically, if the tenant was, informed or told that additional evidence is needed, the tenant would have 1 day to bring to the city additional record.
Yes, and in the decision, it notes the hearing record was kept open until Friday, January 17th, 2025 at 5 p.m. to allow the tenant to produce any documentation to determine what amounts he paid in rent.
Okay. Yeah,
That's page 2 of the decision.
Yeah, I just wanted to hear that for the record. Thank you so much. Thank you, sir.
And Chair, if I might answer
Please.
Commissioner Copeland's question. So the 3-year period is 3 years look back, but it doesn't preclude the chance that a landlord would continue to do a rent overcharge. The law doesn't prevent the hearing examiner from looking at things going forward. It just stops them from going back too far. So you only get 3 years back.
And to clarify for me, I'm sorry, that's what you can be reimbursed for. When they determine the MAR, they look all the way back to the initiation of
Correct.
Yeah.
That is
so
right.
even though you lived there 10 years, you might have been overpaying for all 10 years, just hypothetical again, you would only be able to get reimbursement for the 3 years, though the MAR going forward would be based on the entirety of your tenancy.
That's right.
Okay. Additional questions or comments? Commissioner Copeland, I see you, and then we'll go to the Vice Chair.
That was my question. Thank you, Chair.
Thank you.
Yeah, I do have a question for Mr. Martz, if I could. So when we're talking about in the RSR section 60020, it says that it needed to be supported by the preponderance of the relevant and credible evidence, and that it would not be supported solely by hearsay evidence. But if there's verbal testimony about the rent amounts that were paid during the periods that no receipts were provided for at the time, even if this testimony was not disputed by the landlord that that's what they were paying, that's not considered to be sufficient credible evidence to warrant reimbursement for those months that were missing receipts. Is that the way I read this? Is that correct?
Yeah, the burden of proof is on the tenant, and so one could presume, that there was a rent overcharge every month, I suppose, but without any specific documentation of that, I think it would be hard. I'd be hard pressed as a hearing examiner to make that finding. And so that's why they left the record open to provide those.
Even if the facts were not disputed at that time at the hearing?
Yeah, I would have to reread the decision in full about there's a difference between saying I don't agree or, I'm not disputing these or just remaining silent.
Right, correct. Okay, thank you, Mr. Barnes.
You're welcome.
That's it for me, Chair.
Thank you. Vice Chair Roy, you had a question?
So testimony alone would not be enough to establish that rent had been paid?
Testimony alone is enough.
It is.
Yeah, testimony alone is considered evidence to support a decision. But the question before you is there substantial evidence in the record to support what the hearing examiner decided? I think, you know, most cases like this, MAR cases that we see, are based upon financial documentation and not testimony. But if you had a decision before you that was solely based on testimony, it could be upheld. I just think that would be very rare.
Okay. And my other question was, so I understand it fully, the amount of the potential credit for an overpayment in this particular matter is going back from, if the registration was filed in 2015, 3 years prior to registration, all the way to the application is the potential window.
Correct.
Subject to the proof requirements.
It was 2012 or 2013 to 2025 is the window, and that's in the decision of what his window is.
Thank you. Additional questions? Okay. Who would like to begin deliberations? I'll speak up and gone last the last couple times. I will suggest that context. I've actually gone to the city for a MAR determination because I had had a previous rent reduction in my. When I go to pay my rent each month, it shows that I'm in the arrears almost about $10,000 now because of the landlord not correcting the amount in the portal. And so I got scared that, you know, someday the landlord's going to sell this property and the new person's going to come in and go, you owe all this money. So I went for a determination just so I'd have some documentation. Turns out that I was overpaying by 2 cents a month because based on the calculation. So there was no windfall on my part by any stretch of the imagination. But I went to get that document simply for the purpose of showing that I wasn't actually negative in my account. That history to say, it took me, and I think I'm a relatively smart person, but it took me probably 10 to 12 business hours to come up with that documentation going back to determine, and I walked into the hearing with all of that documentation, but it took me that amount of time. And so I simply believe that the hearing examiner here determined that he needed more evidence, that there was potentially more evidence there, and giving one more business day was completely insufficient to come up with that evidence. And so I think that the evidence shows that the tenant made a good faith effort to provide enough evidence that assumptions could be made in conjunction with testimony. And so I don't believe we should reverse the hearing examiner because we don't have that evidence, but I do believe that the hearing should have been kept, the hearing record should have been kept open just slightly longer than what the hearing examiner said. So for that reason, I would support a remand in this situation. Anyone else? Commissioner Copeland.
Yeah, I actually, my last question that I didn't ask Mr. Marks was if we had the authority to remand in this case.
You always have that power.
We always have that power, even though this is a little bit unusual, correct?
Yes.
Yeah, my concern is that there was testimony and that testimony was not disputed, and the only thing that was lacking was all of the rent receipts. And so if there's a way, I would certainly be amenable to go along with that as well, if the commission agrees. Thank you, Chair.
Commissioner Goldman?
So, yeah, I was going to ask the same because it looks like in the notes here that he provided some additional records by the deadline, but again, I think 1 business day probably just was not sufficient to gather the rest of the information. So I would also support a remand.
Commissioner Thompson, Vice Chair.
Just before I state my position, I just wanted to ask if that 1 day keeping record open, is that the required 1 day, or that's the examiner chose to do 1 day?
That's the hearing examiner's decision. There's no requirement that they actually provide any days because the burden is on the tenant to provide it in the application prior to the hearing. So it's technically a benefit that was given that's not required to keep it open even for a day.
So, you know, I see where the commissioner is leaning towards the remand, right? That's what you, for the tenant provide additional. Let me hear from Vice Chair first.
This one's a tough one. I'm a process person in my profession, in my life. I really rely on rules to be laid out for what's due when, and that's how I structure a lot of my life. And there's something to be said for having these rules established and sticking to them, even when you get in a situation where it seems like, oh man, if I could have, you know, if we could have just have put these records in, the result would have been drastically different. But we're not really supposed to go back and unwind what could have been had we been the one who was filing the appeal or pursuing the application. And so that really weighs heavily on me because I don't feel comfortable making an exception so that a deviation from the process could occur. Ironically here, there was a deviation from the process temporarily for one day to allow additional records to be submitted. I guess it would have been hard maybe in 24 hours to get that, but I don't know, that there was an opportunity. At what point do we say for both sides, because we have to think about both sides, stick to the process, stick to the process. And I just don't feel really comfortable substituting my thoughts standing here today for what could have been submitted with the application or at the hearing examiner or with the one-day extension. And I guess I don't really want to substitute my judgment for what the hearing examiner should have said. What should he have given the tenant? A week, 10 days, 30 days? Now we're down this whole slope of how much additional time do we think should have been given? And so for that, I'm probably not going to vote for a remand, but if the commission decides that they do want a remand, my suggestion would be specific about what you're going to ask the hearing examiner to do, to give an additional date for additional documents to be submitted or something along those lines, because I think that process has to be really clear for both sides to know. So include that in your remand if you're going to go in that direction, but I don't think I would support, because I live in, I'm such a strong proponent of the process, not substituting my judgment for the hearing examiner. And in this instance, I think the hearing examiner did what he or she thought was the right thing to do in these circumstances. The records weren't submitted with the additional time, and the cards fell where they were. So I don't have enough here to say that was clearly an error or an abuse. I think they followed the process the way they were supposed to. So I just, for that reason, couldn't support the remand.
Thank you.
This is what I'm thinking. So this hearing process can be very confusing for the tenants or for anyone, actually, not just tenants, the landlords also, because it's an administrative process. There are a lot of things, nuances, details that may confuse the party or may not be so clearly presented, by the examiner, what's needed. But the fact here is that the examiner himself or herself kept the record open even for 1 day. So the examiner kind of opened the door, welcoming more evidence. That's also, I cannot ignore it. So it seems like the examiner said, okay, fine, bring me more stuff. But unfortunately, reasonably thinking 24 hours after the hearing, and it's Friday, right? I believe it was only Friday. I'm not sure if that's 24-hour, if you really want to open that door to bring more evidence of one day or 24-hour on Friday, is it reasonable? I'm not sure. On the other hand, I also don't see that remanding the case, it's kind of never mind, I will just withdraw that. I'm not going to say that. But let me put it this way. So I don't think that is something, it would be really awfully wrong to remand, since the examiner opened the door and welcomed additional evidence. So I would probably leaning towards the remand. Although I agree with the vice chair that I'm myself more of a structural person. There is a process, and there is process for that, for some reason, for everybody to follow it. But the only reason why I would agree with the remand in this particular case is because the examiner kept the record open for 24-hour, inviting more evidence to be presented. So that's the only reason. If that wasn't done here, if the record was closed, I would not remand this case. Thank you.
I agree completely, Commissioner Topchin, and so since I'm the one who suggested a remand, I'm going to take a stab that we, and I will lean on legal counsel to help with this, because I think that we need to give specific direction, like the vice chair said, and I think that the remand would be to open the record simply for proof of payments. And does it need to be more specific than that, or?
So on a remand, you're limited in what you can tell them to do. So you wouldn't be telling them to open the record or anything like that, because that is the nature of a remand. The record will be open again. So you need to be clear about what it is you were looking for that was missing in this case, either in the record or in the decision.
I would suggest that what is missing in the record is proof from either party, recognizing, though, that the proof of the burden is on the tenant, but from either party of rent payments through the period being discussed. Is that specific enough for you, or?
Yeah.
Maybe you can say it a lot better than I can.
So your motion is going to be to remand this decision to review the entire period. I'll put the specific dates. And to provide an opportunity for the parties to submit additional evidence.
I think that captures my motion. That is my motion, unless the vice chair wants to help make it better.
And include a specific date by which that has to be done, so that there's no more additional extensions or something.
Can we direct, a question of legal counsel, can we direct the hearing examiner not to keep the record open beyond the hearing?
I think you would structure it as with a recommendation that the parties are required to submit the evidence in advance of the hearing. We can't tell them not to, but I think that would send the message of what you're trying to accomplish.
And I think that makes it clear to all the parties, this is that last chance to provide evidence. I'm comfortable with that recommendation, and I appreciate the vice chair, even though I anticipate a no vote on the motion, making our motion better. And that's the reason there's 7 of us on the commission. I have a motion. Is there a second?
I can second it.
Okay. Any further conversation, or do we need to wait for legal counsel to draft something, or is that sufficient?
No, you can vote, and I'll type it up here shortly.
Okay, thank you. With that in mind, Ms. Thornton, may we have a roll call, please?
Commissioner Copeland?
Aye.
Commissioner Goldman,
Aye.
Commissioner Topshin,
Aye.
Vice Chair Rory,
No.
Chair Bass.
Aye. That motion carries. And if the parties have any further questions, you can reach the Rent Stabilization Division at 323-848-6450, by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. That concludes our appeals for this evening, and if you folks are ready, we'll move on with the agenda. Okay, shaking their heads yes. So do we have any additional items from staff?
No additional items at this time. Thank you.
Thank you so much. Item number 11 is public comment. Do we have any speakers who would like to address us?
Not at this time.
Thank you very much. Now we'll turn to items from commissioners. Vice Chair Roy?
I'll just say I appreciate being reappointed as one of the at-large, and congratulations to Commissioner McCafferty, or soon-to-be Commissioner McCafferty, and I look forward to working with anyone for the next 2 years.
Congratulations.
It's very exciting to have a full commission, well, very soon have a full commission back again. I just want to, it's rare that we get to meet on a holiday, and in the city of West Hollywood, it is Harvey Milk Day. I don't know if it's a state holiday, but I know it's a holiday in West Hollywood, so I just want to acknowledge Harvey Milk Day and his legacy officially in our minutes, and congratulations to all of my colleagues on joining us for another 2 years, hopefully, in these roles. And thank you to staff for getting us through some pretty complicated appeals this evening. We really appreciate it. So,
Always.
with all that, no other comments? Seeing none, this meeting is adjourned to the next regularly scheduled meeting of the Rent Stabilization Commission to be held on June 12th, 2025 in West Hollywood Park Public Meeting Room, Council Chambers, which is this room. Have a good night.